Hi, everyone. I'm Katie Donahue. I'm a Denver city attorney. I work in the mental health unit, and what we do is we prosecute, quote, mental health proceedings, mental health civil commitments in the state of Colorado. So I want to talk to you today about commitment proceedings from the state's perspective. Okay, a little bit about myself. I graduated from law school about 10 years ago at this point. I can't believe it's been that long. I was a public defender at the trial and appellate level for maybe about 5 years. And I always wanted to do more for my clients and the people that I worked with. And I got really tired of being told by my supervisors that I wasn't my client's social worker. So I quit being a lawyer and became a social worker. I got my MSW. I worked in that field briefly, but I worked in forensics. I worked at a community corrections facility, which is a state-run halfway house in the state of Colorado. And then I also worked in a competency restoration program uh, that was in jail. So that was an interesting experience. I applied to my current job kind of on a whim, and it's been the perfect fit for me. So I'm in a unit with myself, another attorney. We have a kind of part-time third attorney and a paralegal. We're known as the mental health unit. And the main part of our job is we handle the mental health certifications, which is what we call our civil commitments. And we also handle involuntary medications and involuntary special procedures, such as involuntary electroconvulsive therapy and involuntary feeding tubes for persons with eating disorders, as well as people who um, require oral psychiatric medications but cannot take them in. Um, in addition to that, we also do involuntary commitments, which is the terminology that we use for persons with substance use disorders. So we get involuntary treatment for up to 9 months for people with substance and alcohol use disorders. And then we also help out with involuntary placement for persons with intellectual and developmental disabilities. When someone's at the extreme range of that and needs to be placed in a special housing situation. Another new thing that we're doing is we're doing the extreme risk protection orders, which are known as red flag laws and to a lot of people, but we handle those for the county of Denver, and we work very closely with police. And then starting next year, our unit will be handling our restrictive housing bill, which was passed and goes into effect next July. So people are entitled to a hearing when they're in custody and they're placed in restrictive housing and solitary, things like that, due to their mental illness. So today I'm going to give a brief, I'm trying to be as brief as possible, overview of our legal proceedings, just so you get a sense and context for the work that we do. I find that Colorado is sort of a middle ground when it comes to the rights of respondents and how intense our hearings are and how intense and how many statutory requirements there are to place someone under an involuntary commitment. I also want to talk about what, quote, prosecution looks like, and there's a reason why it's in quotes, so stay tuned for that. And then I'm going to talk about the ethical considerations and provide specific examples that have come up in my work. And throughout this discussion, I want to highlight the rights that are afforded to the respondent in these cases. So I'm going to give you a brief overview of our legal process, but if you want to go back and refer to this slide, feel free. Our civil commitment is codified. Our involuntary feeding tubes and involuntary medications and involuntary ECT are not codified, but it's all under Title 27, Article 65. Before any involuntary commitment can start in Colorado, there has to be a 72-hour mental health hold. And there's two ways to that. There's the one that a lot of people are quite familiar with, which is what we call an M1, but it's a 72-hour hold placed by law enforcement or an emergency service worker in the community when someone's having a mental health crisis. The other way is a court-ordered 72-hour hold, and I'll talk a little bit more about that when I'm discussing my role. So after someone's placed under that 72-hour hold, they must be evaluated, and if they are evaluated and determined to be meet criteria, which we'll go over briefly again. They can be placed on a short-term certification, which is up to 3 months. That can be extended once, extended short-term certification. Once we get to the 6-month mark, it converts over to a long-term certification, which lasts 6 months, and that can be extended indefinitely. And the oldest case that I can think of on my caseload is actually from 1992. So these things can go on for quite a while. The way that the case gets started is once they're on a hold, a psychiatrist or a licensed psychologist will file paperwork with the court stating their reasons for why this person needs to be placed under a certification. At the same time, they can also file a letter for involuntary medications or involuntary special procedures. Once that is filed, the respondent is entitled to immediate appointment of court-appointed counsel. In Denver, we don't really look to whether they can afford an attorney. One is just appointed to them automatically. As you can imagine, it might be difficult to determine their finances at the time that they're being placed under a short-term certification. In Denver, also as part of the court-appointed contract with the court, that attorney, that court-appointed attorney, has to visit with them within 10 days of their appointment. We'll talk about this more in depth, but my role in the city attorney's office is essentially to act on behalf of the petitioner facility. It's very rare that we're not acting on their behalf. And then the respondent is entitled to a hearing or a jury trial to 6 jurors in district court. In Denver, it's actually Denver probate court. Upon filing a written request for review of the certification. In the alternative, or on the other end of the spectrum, once the doctor files a letter for involuntary medications or involuntary special procedures, the court has to set that within 10 days. And the obvious reason for that is if someone's needing involuntary medications, they need a hearing to get that administered as soon as possible. And a little fun experience that I had was our court really does respect this 10-day limit. I once had a jury trial request on a Thursday. The court set it on Friday to be heard on Monday. So that we went forward, full jury trial. It was a very fun weekend for me. So I want to go over the standards in Colorado. I believe that they're pretty similar across different states. They might be titled different things, but it's essentially these 3 things. So a danger to self, a danger to others, or gravely disabled. And I think what's really important to note here is we're no longer looking at imminent, not imminent danger to self or others. When we get to the certification, we're looking at recent danger to self or others, but not necessarily imminent, which is more with that 72-hour hold. So I'm not going to read you the legal definitions, but I'll give you a brief overview and provide some examples. So when we're talking about danger to self, obviously we're talking about suicidal ideation, attempts at suicide, but also self-harming behavior, cutting, head banging. And that's not only just for people with suicidal intentions. We can see danger to self in other direct ways, such as someone who's experiencing psychosis and banging their head to get rid of the voices, or we'll see people cutting their arms in order to dig out some perceived implant or microchip. So things that are a direct harm to oneself. Danger to others, we're looking at threats or acts of violence towards others. One case that comes to mind is we had this young gentleman who had capgras delusions, and he believed that his family had been replaced with imposters. So he assaulted them with a frying pan in his home. So that would be a danger to others. And I like to think of when we're talking about these standards and moving forward with time, I said it didn't need to be imminent, but let's say someone threatens suicide, they might not be a danger to self 2 weeks from now. But that fellow who assaulted his family, even if he doesn't really display any dangerous behaviors for a while, he still might be considered a danger to others for quite some time due to the gravity of the incident that led to his hospitalization. Um, for grave disability, that's quite a long definition. Um, Basically, we're looking at whether someone, due to their mental illness, it causes impairments to the point that they can no longer take care of their basic needs. So, someone who is placing themselves at risk of harm because they can't navigate the community safely due to disorganization, or they're not eating or drinking due to delusional thought content. They won't be able to find safe shelter. They wouldn't be able to go into a store and buy groceries, let alone cook them for themselves. Um, we also, in Colorado, we have a broader definition than I feel a lot of states have. And I don't even know if a lot of people in Colorado are aware of this, but gravely disabled was expanded within the last 10 years to include they're gravely disabled, they can't take care of their essential needs. And one of those essential needs being taking medications so that they're at risk of a significant psychiatric deterioration. So let's say we have a respondent who's on a long-term certification. They've been doing well, they've been taking their medications. However, they continue to lack insight into their mental illness. They don't think they're sick. They don't think they need medications. So for someone, let's say schizoaffective disorder, for someone having that, maybe medications are an essential need, and they aren't able to attend to that. So without the certification, if they're at risk of a significant psychiatric deterioration, the court can find by clear and convincing evidence that they are gravely disabled. I think one thing to point out, I know I'm talking to a lot of different people today, but for those of you who are in the community placing mental health holds, so again, the law enforcement, the emergency service workers, I think it's very important. I know there's a lot of frustration about bringing someone to a hospital and then they're released very shortly. If you're filling out the form and alleging one of these, the more details, the better. And that comes to my desk, right? I'm seeing what's being written down. And the more details, the more likely the professional person, the psychiatrist, psychologist, might keep them longer than a few hours. And the more evidence I'll have going forward to keep them hospitalized if that's what's necessary. So a lot of people don't know what actually goes on in the courtroom for certifications. If the respondent requests a hearing or the facility has asked for involuntary medications, it's a hearing just like any others. So in my office, I really stress when I'm training my new attorneys, we are going to hearing to deprive someone of a substantial liberty interest. We're locking people up against their will, introducing chemicals into their bodies that they don't want there. And they've done nothing wrong. The only thing they've done is they happen to have an illness. So our hearings are quite long in Denver. They can be they're usually 1 to 2 hours long. And we make sure that we hit every single legal requirement by clear and convincing evidence. So we don't take too kindly to doctors who feel that this process is just a rubber stamp or it's a waste of their time. And that is a surprising attitude that we see. We like the facilities to recognize that they are taking away someone's basic human rights. Um, so yeah, it's just like any other hearing. We're allowed to give an opening and a closing. We go first as the people. Um, we will usually call the treating psychologist or the psychiatrist if we're requesting medications first. If there's family members involved, we will call them, but I'll get to that in a bit, how that's actually quite rare. We also have the ability to call the respondent. They don't have a Fifth Amendment right to remain silent in these hearings. But this is where ethics and clinical opinion comes in. We're not calling the respondent to make them look dumb or like highlight their delusions. I really just ask questions to give them a voice. Sometimes respondent counsel doesn't want to call them because they can usually make the case against them for themselves. But I think if they want a hearing, then they have the right to speak during that hearing. So I just asked them, what would be your plan if the court agreed with you? What do you want to come out of this hearing? And I basically leave it at that. So the respondent side, so once our case is done, the respondent can also present evidence, but mostly their court-appointed counsel will just cross-examine the doctor. I've seen respondent counsel call family maybe once or twice throughout my 4 years at this office, but it's very rare, and we'll get into that in a bit. One thing I wanted to note with the hearings is that my office is very aware that the relationship between the respondent client and the treating professional can be really damaged by these hearings. So it is really hard. You need to be, as a professional, you need to be really sure that this is helpful for the respondent, because the testimony that you're going to provide is not going to be easy to hear for the respondent. So we're very aware of that. We don't ever, again, just like when we're questioning the respondent, we're not really trying to have the doctor bring out the worst of the worst. We kind of make it legalese so that it's not too upsetting to anyone. So prosecution, it's in quote. The reason I put it in quotes is because I don't view myself as a prosecutor. This isn't the people versus the respondent. These hearings are the people in interest of the respondent. We're trying to do what's in the best interest of the respondent. And we don't represent the petitioner. We don't represent the doctor. We don't represent the psychiatrist, psychologist, or even the facility. We represent the people of the city and county of Denver. In the statute, our role is to, quote, conduct the proceedings. However, 99.9% of our cases, we, the people, agree with the petitioner that it would be in the respondent's best interest to have involuntary treatment. We also handle appeals. So respondents in mental health proceedings have the right to a direct appeal, and quite a few do appeal. They also are entitled to court-appointed counsel on their direct appeal. And maybe this year we've had about 1,000 cases filed, and I think we're maybe at 5 appeals for the year. Those are also very quick. The Court of Appeals also recognizes that these are emergent matters that need to be heard. So we only get about 2 weeks to file a response and file the respondent counsel to file the opening brief. So it's a very tight deadline so that they get an opinion out. And if the respondent is being illegally held, that they're released as soon as possible. And in the world of appeals, we know that can take some time, but they really do a good job speeding that up. One of the things I wanted to talk about, and that first bullet point, we were reviewing cases for legal sufficiency. We'll file motions. We interview the doctors. We have definitely dismissed cases because there's not enough written. So that's a good example of how we're not representing the petitioner. The petitioner files something, and you have to have a factual basis for why you believe they're mentally ill and for why, due to their mental illness, they're a danger to self or others or gravely disabled. And if some doctors will just write 2 words, grave disability, well, that's conclusory, and we will dismiss those cases. Um, so I think that's important to keep in mind going back to the emergency and law enforcement filling out that initial mental health hold. Doctors should also be held to an even higher standard when they're filling out something to take away someone's rights for 3 months, 6 months, and maybe since 1992. One of the other things we do, which is kind of, I'd consider one of the most difficult parts of our job, is earlier I spoke about the court-ordered mental health hold. So any responsible person can petition the court to have someone placed on a 72-hour hold for evaluation. The court in recent years, because we're conducting the proceedings under the entire statute, has referred all family members, neighbors, loved ones that go into the court looking for help. They're referred to our office. So we assist, I'd say 9 times out of 10, it's parents of an adult child who's suffering from a severe and persistent mental illness. They will call us and we will lead them in the direction of getting a court-ordered evaluation. This can be an extremely frustrating process. I remember there was one parent, and I think we filed 3 petitions for court-ordered evaluations. And because the way the law is, they didn't happen. It didn't work out. They were evaluated and released in an hour, or law enforcement went out and didn't think they met criteria at the time, despite having the court order in hand. So, and even when this young man was placed under a certification on the 4th try, he was terminated from that certification too early. So I almost feel like I'm a clinician again and dealing with these family members calling for help. It is an extremely frustrating system. We don't have the resources and services that we need to make sure that everyone who needs a mental health evaluation gets one. And we don't have enough beds that someone who needs a little bit of inpatient treatment can get that. It's very difficult, and it can be extremely frustrating. But I also recognize the struggles that the other side has, and there are limited resources. Doctors at facilities are short-staffed, so they're basically doing triage. So is this person sicker than the person on the bed next to them, who could be incredibly psychiatrically ill as well? So it's not the greatest situation all around. Another thing I just note on the slide is in Denver, we try and be very proactive. We just recently had a complete rewrite of our statutes. So we give a lot of trainings to all of the facilities and doctors who are filing certification. We like to educate them on the new law, make sure that everyone's in compliance with the law. So there's a lot of outreach. And we also try and maintain really good relationships with the doctors and, well, psychologists are doctors too, but all the doctors that we work with in our field. Yeah, that's a part of my job that I really enjoy. So ethical considerations, obviously this is always coming into play. I said earlier, we're working under the clear and convincing standard. And for those of you who don't know, you think about a civil trial, if it's 51% you win, 51% of the evidence in your favor, you win. And then we can think of beyond a reasonable doubt in criminal trials, which is a very high standard. We're somewhere in between. It's a civil case, it's an intermediate standard, but it is higher. And we are expected to present a lot of evidence to take away these people's rights. We're always working in the best interest of the respondents, and we're always balancing the rights of the respondents and their needs, which can be difficult. Sorry, I jumped slides. I wanted to give an example of a case where my ethical considerations came into play. I was in a hearing and there was a doctor who didn't want to prep with me beforehand. But basically, the testimony of the doctor during the hearing, the pleadings were fine. I thought this would be a great hearing. His testimony was that this person's insurance was running out and they were releasing them tomorrow. But he was trying to argue that this person was gravely disabled and couldn't attend to their essential needs to the point that they're going to be at risk of bodily harm in the community. And that didn't sit well with me. If you feel that they're going to be fine tomorrow for discharge. And it didn't help that this doctor kept asking on the record, how much longer is this hearing going to be? So I made a judgment call. Obviously, I'm just conducting the proceedings, so I didn't dismiss them outright, but I let the doctor present his evidence, and then the court, decided to dismiss that case and release the person that day, instead of waiting until the next day when their insurance ran out. So we have to make these calls and hearings all the time, and it can be hard. We hear the testimony of the doctor, and sometimes the respondents present really well, but the testimony of the doctors, pretty damning. So again, we get to fall back on conducting the proceedings. So we just present the evidence and the court will do what they will do. But I know I said we don't consider these hearings to be a rubber stamp, but it's very rare that we lose. I think the people that the facilities are willing to file a certification on in Denver, those all have a lot of merit. There's no close call cases. I don't think we have the resources to involuntarily hold the close cases. So that makes my job a bit easier. So I said I would talk about family involvement. We do assist the family members when they're trying to get that initial mental health hold from the court. However, we don't really see them past that stage. So I wrote some recent changes. The one recent change is the respondent may designate a layperson. This is in the new statute. So they can designate a family member, a friend, someone that they have in their lives to participate in all the legal proceedings, in addition to having the court-appointed counsel. HIPAA still applies to all of these proceedings. So let's say a family member calls me up, a mother calls me up asking about her son who has a certification proceeding. HIPAA still applies. I should not and cannot be sharing their protected health information unless there's a ROI, and I'll always direct them to talk to the facility and the doctor. Another interesting thing is hearings are not closed to the public. They're not statutorily closed to the public in Colorado. Someone has to present good cause to close it. So if the respondent wants his hearing closed to the public, I'm never going to object to that. I don't necessarily agree with the law in that aspect, but you got to follow it. So going back to the hearings, the certification, the civil commitment hearings, I have a lot of speculation as to why that family doesn't really want to be involved. I think since family members can't be petitioners for a certification in Colorado, that's why they're not really involved. It's always going to be that doctor. A sad truth is that many of the cases, the people that come across my desk, they've lost their natural support systems. They don't have family or friends there to go there and testify. We see the most involvement of family in our eating disorder cases. So Denver, Colorado is unique because I think we have the only medical stabilization unit for eating disorders in the country. So we're one of the few states that can do involuntary treatment for people with eating disorders. So that is where we see the most family involvement, and generally it's parent involvement. However, every single case that I've had where the family is quite involved, the family absolutely does not want to participate in the hearing. Um, the family will call me and tell me that they absolutely think that their child, the respondent, needs treatment, but they absolutely do not want me to tell the respondent that that is the way they feel. And going back to the damage of the therapeutic rapport between the treatment provider and the respondent, you can imagine with a family member, you don't want to damage that natural support system. And the parents don't want their child to feel that they're out to get them. So we respect that. I've never forced a parent to testify against their will. Generally, they just don't want to testify. And we always have enough expert testimony of the doctor to make our case. So that is all I have. Please feel free to reach out to me. I left my email here. I love connecting with other people and answering questions that you might have. So I just want to thank you all for listening to me for the last half hour.